Thank you and welcome to the Court of Appeals. We have for oral argument next the case of In Re JT. This is our second oral argument of the day, one of 4 cases for consideration. We'd invite you to enter your appearances.
Thank you, Your Honor. Christopher Bynes, appearing on behalf of the appellant.
Thank you.
Martha Pierce, attorney guardian ad litem for the minor children.
Thank you.
Tom Peterson, Assistant Attorney General for the State of Utah.
Thank you all. How have you decided to split your time?
Down the middle.
Down the middle.
Yes.
We'll let you manage that.
Thank you.
Thanks. And it looks like, Mr. Bynes, you've reserved 3 minutes for rebuttal. Is that?
I have, Your Honor. Thank you.
Okay. We'd ask you as you come to the mic to again say your name for the sake of our audio record and those that may be listening online. And you know you've got a clock, but if we're asking questions as time expires, of course you're welcome to finish answering a question in our exchange, even if the clock's at 0. And with that, Mr. Bynes, you're welcome to proceed.
Thank you. Good morning, Your Honors. It's a privilege for me to be here before you. I'm not going to proclaim to be a great orator. I much prefer to rely on the briefs that we filed here today. I would like to just make a few comments for the court. We believe the fundamental question here today is whether Rule 24A2 of the Utah Rules of Civil Procedure allows intervention in this case and whether the district juvenile court failed to apply the Rule 24A2 analysis thereto. My client's position is yes, as to both. URCP Rule 24A2 requires a court to permit a person to intervene who claims an interest in the subject of the motion or of the action and whose ability to protect that interest may be impaired or impeded by the court's disposition of the action at hand.
So how do you look at your client's interest in the proceeding? How would you define that?
Her interest in the proceeding, first off, is as a grandparent who, with regards to JT, she probably cared for the majority, well, I wouldn't say the majority, but a very good portion of the child's life.
So it's as a potential placement option. That's basically her interest in this proceeding.
And potentially.
Right? Am I right about that?
You're correct, Your Honor.
Okay, so it seems like as a potential placement option, she may have an interest in where the child is placed if it's not back with the parents. Fair?
Correct.
So it would seem to me then that she wouldn't have an interest in adjudication.
As far as adjudicating where the child would be on a temporary basis.
No, adjudicating abuse or neglect or dependency. I mean, I'm trying to figure out whether she's got an interest in the entire case or just some of it or whatever, and it seems like there are big phases of this, of a juvenile court child welfare proceeding where somebody who's just a potential placement option doesn't have an interest, right? Adjudication being one of them. Like, did the parents abuse or neglect these children? That's something that's between the state and the parents, right?
The state would be bringing the action against that, yes. My client, who has reported this thing to, these matters to DCFS multiple times, certainly has an interest in stepping forward and trying to protect the best interest of these children.
All right, well, so you cited the case of FL versus Court of Appeals in your blue brief, right?
We did.
And I guess I'm interested in knowing from you why we're talking about Rule 24 intervention and not about sort of limited purpose intervention as set forth in FL and State v. Brown. That seems a far better fit for you. I mean, I'm struggling with the notion of allowing somebody who's just a potential placement option to be a full-blown party for the entire length of a juvenile court case would give her access to the file, would give her access to confidential stuff. That just feels like that's too much to me, whereas a limited purpose party would seem like a much better fit for the argument you're making, given that your client really only has an interest in discrete portions of the proceeding. And is that an option you considered making, or what do you think about that?
Well, in all fairness and in all honesty, Your Honor, we didn't actually find this FL case until after we had filed a motion to intervene, and I believe it was after we filed a petition before this court for appeal. And so that is an interesting concept, and it's something that we haven't looked at applying in this situation. I'm not suggesting that it wouldn't apply or that it wouldn't work. It's just not, it wasn't on the table at the time when all of this came down.
Okay, what do you think of my statement that seems like a better option here than letting somebody like, somebody who's just a potential placement option in for the duration of the case with full access to the file, period?
Well, again, I hadn't given it a lot of thought until, obviously now. It would certainly, I mean, I can see the benefits of that, as the court mentioned, it would perhaps secure or safeguard some records. In this situation, however, and perhaps the court's concern is that if the court was to grant in this situation an intervener's motion, then it opens up potentially Pandora's box.
Well, it seems
Is
like
that the
Rule
court's
24
concern?
is binary, right? Either you're a party or you're not. Right? So, and if you're not a party, you don't have the right to appeal anything, for instance, which I think you're concerned about.
We are.
But if you are a party, then you're a party for all purposes. You get access to the file. You can be heard at every stage in the proceedings. You have those rights as a party. And that just, if it seems like the concern there is that if we held that under Rule 24A2, anybody who's even a potential placement option in a juvenile court child welfare case could intervene as a full-blown party. Well, I can imagine. Can you see some problems with that potentially?
Potentially, we could, yes.
And how would you respond to that Pandora's box concern?
Well, and the reason I bring that up, because I have considered that, and perhaps that, and it's difficult. I would say it is difficult for the court to say, well, it's going to be difficult for us to pick and choose, and in essence, you'd be trying to, I don't know that you could equally and equitably apply that to every circumstance and in every case. And so, obviously, in this case, we would be asking that in this situation, that would apply. And as a reading under Rule 24A2, it doesn't appear to me that rule discriminates as to who can file or for what purpose. It simply says if you meet the language, you have a right of intervention. And so our position is under the rule, despite the possible consequences, my client would have a right to intervene. Does it create problems within the rule in the law? Perhaps.
What would you have wanted for your client in the shelter hearing that you didn't get for your client?
Obviously, for the child to be with my client, there were procedures.
Sure, the outcome, but I guess procedurally,
There was never any, to our knowledge, what we received in the initial court hearing was that DCFS, the state had made their findings already. They'd made their opinion through the investigation of somewhat of a best interest analysis for the children. And I think that the main reason was that they wanted to keep these two boys together, which they're not together at this juncture. But that's what they proclaimed to be. And
Well,
so,
that's a new development, isn't it, since the briefs? Weren't they together at the time of the
they
briefs?
were.
Okay.
So,
But to follow up on Judge Luthy's question, procedurally, it seems like the difference between how that hearing would have gone forward had your client been a party versus how it went forward in reality is what? I mean, your client was there, your client got to file things, your client got an opportunity to be heard, you were there, you made argument, and the court ruled against you. I guess I think Judge Luthy's question is, well, how would that have looked different if your client had been a full-blown party when the court encountered the question of the merits of where the child was to be placed versus how it went as in reality?
well, we believe that she would have been placed on a different standard and a different pedestal than where she's at now. And as a party, she would have had the opportunity to present evidence as to her adequacy for the placement.
One of the differences is you wouldn't be here, right?
That's correct.
No, what I'm saying is you wouldn't have a right to appeal at that point.
We wouldn't have the right to appeal, other than obviously this motion for intervention, we've appealed that. But the denial of her being placed as a party would deny her the right to further appeal.
In other words,
Is that your question, Your Honor?
Yeah, that's,
you're here today appealing only the intervention denial, right?
That is correct.
Because the merits of the decision, number one, it's a non-final order, the shelter placement, right?
Correct.
And number two, because the intervention was denied, you're not a party and therefore you can't appeal it.
That's correct.
So for two reasons, you can't appeal the merits of that decision. You're only here today to contest the court's decision denying your motion to intervene, right?
That's correct.
Okay.
Tell me what you think about this idea. Section 80-3-301, has to do with shelter hearings, does talk about someone who has, I think it calls your client a requesting party, and the rights of a requesting party to put on evidence and have counsel present. Seems like there's some, it's not a lot, but there's some detail as to how Section 302 says that your client can file a request, and it seems like you can't file something unless you're a party. And so the code contemplates these requesting parties being a party to some extent, but then in Section 301 kind of lays out the extent to which you get to participate. And in that sense is maybe more specific as to how a requesting party participates, to what extent they're a party, and it does kind of look like a limited purpose party like NFL and Brown. And and this is I guess what I'm leading up to, could we say that Section 80-3-301 and 302 are more specific about intervention by preferred placement, potential preferred placement, and therefore we look there to the specific statute rather than to the general intervention rule of 26A2. And say, yes, you do need to be allowed to intervene because you can't file anything unless you're a party of some sort. But the world of what you get to do as that requesting party is defined here.
I guess I'm not sure I'm not sure of the question, Your Honor.
But what, I guess the question is, would you agree that the scope of your client's involvement as a party would be limited by the rights outlined in section 80-3-301?
I think it does provide some limitation. It also provides some guidance, and it also, for instance, under section 302.7, it talks about some preferences for placement. And so when we look at this in conjunction, or the entirety of the statute, there seems to be some contradiction in that how can I put this? For instance, the preference would be a parent, a non-custodial parent. That'd be the first preference. And the second preference would be a relative of the child. And in this situation, there was never, with regards to JT, there was never a relative where he was placed. And in fact, the placement wasn't even, they were not even certified as a foster placement. They hadn't even gone through the proper procedures for that. And so that's one of the other issues that we have brought before the court. To your main question, yes, 80-3-301 is another avenue that my client could have pursued. But there again, when we read this, we understood it that she had to be a party. And in order to be a party, we understood it that she had to intervene, or she would be required to intervene. Thus the reason for the direction that we took.
Okay, thank you.
Any other questions, Your Honors?
Probably on rebuttal.
May it please the court, Martha Pierce, attorney guardian ad litem for the minor child. Child welfare is very different than other cases, and when we make analogies to criminal law or to custody law, we almost always run afoul, because child welfare has to do with the status of the child, as you mentioned, as abused, neglected, or dependent. And as you mentioned, there's very different things that happen at the adjudication phase versus the disposition phase, which is why Rule 24 is not such a good fit, but the better fit is Juvenile Rule 18E, which allows for people to intervene for purposes of disposition. The adjudication phase is where we look at the parent's substantive due process rights and have evidence by clear and convincing evidence so that the court can override constitutionally protected parental decision-making. And you're correct that to allow anyone to intervene at that point allows anyone access to highly sensitive information, and also could allow family members to undermine the permanency goal, which in most cases is reunification. And I would point you to 80-3-302, which doesn't just say that a relative has a preference and that's it. It puts a lot of conditions on those preferences. One of the conditions is that the relative has to agree with the permanency goal. Another one is that the relative has to submit to juvenile court jurisdiction, but it's for purposes of disposition, not adjudication. So the disposition is the problem-solving part of the case, and perhaps grandma wanted to be a party of that. That might have been a better fit, but that's not what we're arguing about. So for her to say that yes, I'm a party to the adjudication itself, totally undermines the parent's privacy issues, the child's privacy issue, and the whole fundamental nature of the parent-child relationship that the juvenile court.
So I understand those concerns.
Okay.
I mean, I voiced a number of them
Yes, you
already
did.
this morning.
Yes,
So, but let me just make sure I understand what your position is with regard to the sort of the applicability of the rules, right?
okay,
The juvenile rules, other than Rule 18E that talks about letting other people in for
Right.
purposes of disposition, there's no intervention rule in the juvenile rules, right?
other than that, no.
And
because-
so then we would apply the general concept that the civil rules are importable into the juvenile context unless there's a juvenile rule that sort of occupies the field, right?
Right,
And so it would seem then that Rule 24, civil rule regarding intervention, because there is no analogous juvenile rule, would apply. What's your response to that?
at a high concept level, I would agree, but it would be really difficult to make a case that I have an interest in this child as a relative, when all you really have
Yeah, as a relative, but I can
is an
see,
inchoate interest.
I can see other contexts where Rule 24 might be applicable sort of in the way that we all understand it. Let's take a hypothetical situation where there's some debate about who the father of the child is. The child, say in my hypothetical, has been living with mother and putative father. DCFS sees a problem with the way they're parenting, so DCFS comes in and tries to take the children out of this home. But there's another man out there who says, hey, wait a minute, I'm actually the father.
That
I
happens
need-
all the time.
I need to come in and intervene now because I'm the father and my parental rights should be at stake here too. Would that person be able to take advantage of Rule 24 to intervene as a party for the whole case?
How that normally happens is no, he can litigate a collateral proceeding to establish legal parentage. But until he does that, he's a legal stranger to the proceedings. And that's how they handle it. Because, yeah, he's a legal stranger. And the putative father is also a legal stranger to the proceedings. So he might have standing for purposes of disposition, just like boyfriends and stepfathers often are included under 18E because they're part of the solution, that we need them to be included. But they can't participate until they show they have that legal interest.
And where do they go to show that?
They can file,
Wouldn't they try to prove that in this case as like we would in an
They
adoption?
do it in a
adoption case?
collateral proceeding. Because when you look at the juvenile court jurisdiction under 78A6, it says a juvenile court has jurisdiction to litigate parentage issues. And so they do it in a collateral proceeding. And then if the court determines that, yes, you're the father, then
It would
they-
be the same juvenile court judge making the determination about parentage.
Exactly,
And
exactly.
so it's sort of appended to this case?
It's collateral to the case because until they show that, they can't have access to all the sensitive information that goes on. And the burden's on them. The burden's on them to show that, yes, I'm the legal father. I've established legal
All right,
parentage.
so as a practical matter, you're saying to me that people don't file motions to intervene in that factual setting?
No, and that's a really common.
Yeah, I would imagine
Yeah,
you've seen
it
it
happens
number
all
of
the time, and that's
times.
how we handle it. Because, no, you can't intervene until you show us that you're a legal parent.
Here's the rub that I
Okay.
find, that section 80-3-302, subsection 7, talks about a relative's request for placement of the child.
Right,
And then State versus Brown, which I don't know that it was cited in either brief, but State versus Brown says, non-parties have no standing to file motions or to otherwise request relief. Such rights are conferred only on parties. Section 80-3-302 confers a right to file a request for relative preference placement. And if, by conferring a right to request relief, they've got to be a party in some fashion. And so
And
is
that
it your
would-
contention that this requesting relative just cannot be a party? Or
not to the adjudication portion, just to the disposition. And even though it's pre-adjudication, this is really a dispositional issue. I mean, the court makes dispositional decisions at every single hearing.
Sure.
And so just for those limited purposes, so under 18E, yes, for dispositional purposes. And normally the request is made to the division.
So you're not contending that she shouldn't be able to intervene, but that the intervention needs to be limited?
Correct.
How
Okay.
would you limit it, and what rule or statute would you point to for us to know where to draw those limiting lines?
18E, because that specifies is for purposes of disposition only.
Okay.
So unless there's other.
Yeah, I guess I was confused to hear you say, well, you don't contest limited purpose intervention. I didn't
Right.
get that from your briefs, and that's your
Right.
position today. You think that somebody in this grandmother's position does have the right to come in as a limited purpose party for the purpose of making this request for preferential.
Right, and that happens all the time, sometimes informally through a request to the division, sometimes something more formal by a request to the court for placement or for custody, or sometimes they even file their own petition for adjudication, then they are a party.
And then the juvenile judge would be able to make whatever orders the juvenile judge needed to make in terms of docket management things, in terms of how much of the file this person was able to see, and, when and how she was able to file these requests, but she'd be able to file them and then be able to appeal to us if she didn't like the result, right, as a limited purpose party?
I think 18E is a better fit than limited purpose party, because 18E says for purposes of disposition, and then the judge would, and then if she said, well, I want custody, the judge would say, well, then show me what you got. Let's do an ICPC, let me order, well, no, she's in town, so let's do a background check. The judge would order the division to make certain preliminary checks on her, and then for purposes of that, the court would either rule up or down on her custody request or placement request.
And under 18E, as a 18E limited party, would she have the right to appeal in your view?
Right to appeal a denial of,
Yeah, say she comes in, makes her request under the statute for preferential treatment as a relative. The judge says, no, I'm not going to go with you. I have other reasons, like in this
then the
case.
judge would be ruling on the merits, not can you intervene. The judge would say, yes, I'll place, no, I won't place. And so then we're looking not as, I'm denying your motion to intervene, I'm denying your motion for
Yeah,
placement
we're
for
talking
custody.
past each other.
I think we are too,
I
I know.
thought you were conceding at this point that there was a right to limited intervention, at least under 18E. So there's limited intervention. She gets to come in then as a limited purpose party of some kind, whatever label you want to put on it, whether it's a F.L. and Brown limited purpose party or whether it's an 18E limited purpose party. She gets to come in then to make this request.
Right.
As a party to make this request, for the limited purpose of making this request.
As
Right?
a
My
party.
question to you
As a
is.
dispositional party. Okay.
Yes, exactly,
Yeah.
as a-
Okay,
whatever
okay,
you wanna call it, a
okay, okay,
dispositional
okay.
party.
I'm with you. Okay.
And then the court then makes a dispositional ruling. The person who made the request would then have the right to appeal to us.
This is the first time I've ever seen this posture. Normally, the posture is, I'm denying your motion for placement or custody. And then that's an interim order that gets appealed down the road. But this particular posture, I'm appealing because you didn't let me intervene for purposes of adjudication, because they didn't ask for limited purposes, they asked for adjudication.
I know, that's
So
the problem.
that's the solution too.
It sounds though like that you would be on the same page with the appellant, that there ought to be a reversal, at least to the idea that she should have been able to intervene as a party of some sort, a dispositional party, but that once her purpose for intervention was concluded, that the court heard the evidence and decided we're not going to have you be the shelter placement,
Right.
that her participation as a party would then end.
That's more how it happens, that is more like a collateral action for placement or custody.
The phrase you keep using is how it happens, kind of like this is the way grandma's always baked the bread, and so this is the way it should be. And one of my hangups, and maybe theirs, is we're also looking at the language of the various rules and trying to say, well, where are the lines here? What
Right. principles,
in an opinion, can we delineate for future cases? And let me finish my question, then you can dive right in. 24A2 is discussing intervention as a matter of right, correct?
Right.
18E is a permissive rule. It
Right.
uses the word may.
Right.
Are we talking apples and oranges? You say 18E is the better fit, but it's actually a different animal altogether.
It is a different animal altogether. 24A is a difficult issue because a grandparent or relative, somebody like that, simply can't assert an interest because they only have an inchoate interest. So the most they can do is to file a parallel action, a collateral action for custody or placement, and it should be permissive because the court at the dispositional phase is very focused on a permanency goal. So if somebody's not going to be supportive of that, then the juvenile court, as a problem-solving court, needs that kind of discretion to determine, are you part of the solution or part of the problem? I feel like I'm taking up so much of my colleagues' time that I would like to.
We've turned the clock off, so he's going to get his 7.5 minutes. Don't worry about that.
Okay.
But I think Judge Mortenson's question is 24A2 is not only as a right as opposed to permissive,
Right,
but it's really broad.
yes,
It's all you have to do is claim, not prove,
right.
an interest that is not in but just related to the transaction that is underlying the case. And I don't know, explain to me why under the text of Rule 24, a putative placement, somebody who claims this sort of preferential relative placement treatment wouldn't meet those broad criteria. They claim an interest relating to the
They
transaction.
would for purposes of disposition, not for adjudication.
I understand
Okay,
that there are.
Then I guess we are talking the same.
Well, but the problem with Rule 24 is it's binary. It doesn't talk about limited purpose intervention. It talks about intervention as a party, right? So the argument here is we have this right under Rule 24. We claim an interest related to the transaction. Therefore, under Rule 24, we get to come in. We're just a party. There's nothing in Rule 24 that talks about limited purpose interventions like there is in FL and Brown and like there is in Rule 18E.
Well, I think Rule 2 of the juvenile rules says that where there's a conflict, that the juvenile rules prevail over the civil rules.
But
And
that's
I-
why you just said they're a different animal, though. So is it an actual conflict? One of the other things at work here is the standard of review. You've all agreed in your briefs that under 24A2, the standard of review is for correctness. So going back to what Judge Harris is saying, it's a binary decision. You either fit under the rule or you don't. 18A is permissive. It uses the word may. I don't think there's a case that says this yet. Maybe we're going to be the first one. But that, to me, shouts abuse of discretion. That's a discretionary call, may. Now, all of a sudden, we're on the horns of a dilemma because we have one standard that's correctness, and we just have to answer the question up or down, right or wrong, did the juvenile court err or not? If we look at 18E, then we do have this space where they can say, look, in this circumstance, no, I don't want you, as what you said, you're part of the problem, not part of the remedy. Whether you're the problem or the remedy, I don't think comes under the plain language of 24A2. I don't think there's a space where you can say, I'm going to deny intervention on the basis that you're going to cause me more pain than you're worth. I just don't see that that's a space in there.
Okay, the standard of review is correctness in terms of interpreting the language of the rule. Application of the rule, at least 18E, has got to be abuse of discretion.
That's what I'm saying,
Right.
yes.
But I think the adjudication itself, dealing with something that is so personal to a parent, something that has constitutional dimensions, I think you can't apply 24A to that and to say, I have as much standing as a parent who has constitutional rights.
We're not, well, at least I'm not saying you have as much standing. I'm just saying you have some standing or the appearance of a position on placement. Why?
But placement is inherently dispositional. It's not adjudicative. So I think 18E answers the question, how do we deal with intervention when we're talking about status jurisdiction as opposed to 24A contemplates conventional jurisdiction. Status jurisdiction is a very different jurisdiction. And then on top of that, you also have the constitutional overlay. So I think it's fair to say this just can't apply for purposes of adjudication because of these concerns.
I don't think I was real clear when I asked it before, but I'm going to try asking it again. Could section 80-3-301 and 302, standing alone, be the basis for both granting intervention, but having it be only for a limited purpose,
I think it can.
and that we wouldn't have to look at Juvenile Rule 18E, because that's permissive, and that this would appear to be mandatory, And we wouldn't have to look at 24A because this is specific intervention for this very specific purpose. And 24A is a more general rule,
Right.
and we're going to apply specific over general.
And the portion of 80-3-302 that you're pointing to looks solely at placement. It doesn't look at the adjudicated issue, so I think that's one way to get there.
Yeah,
Okay.
and final question, going to building on what you just said, you're viewing, Judge Luthi, I think, is viewing limited purpose intervention under FL and Brown and these statutes as mandatory, as of right. In other
As of
words, if
right.
a putative intervener can meet these criteria set out in, in other words, if they have the right to make a request under 3027, then they have the right to intervene as a right for that limited purpose. The judge can't tell them no. Like the
No,
judge,
the judge says, I'll look at your, look at your petition. I'll look at,
because under Rule 18E, the judge has the right to tell them no, right? It's permissive.
right.
It's just may. And so this would be a little bit different animal from 18E because it would be,
So it seems like 18E would kick in if the judge, say, granted the petition, and said, yeah, I'll place with you, but I'm gonna put you under court jurisdiction, and I'm gonna put you on a treatment plan under 18E. The court could do that.
But that doesn't go to intervention. That goes to then the ruling that, yes, we're going to give you
Yeah,
placement.
up
And
or
now you're
down.
going to be under
Ruling up or down on the
continuing
placement issue.
jurisdiction.
Okay, let me let my colleague have some time. Thank you.
yeah.
Thank you.
well, do we need supplemental briefing on these issues, do you think? Oh, you're like, you don't want to file.
I don't know if I could enlighten you any further. If you feel like I could, I'm happy to, but I don't know if I
Okay.
could.
Thank you.
May it please the court, John Peterson on behalf of the state of Utah. Oh, now that Ms. Pierce has kicked the hornet nest, here I am. But I think, there's been, talking about, clearly I think what the juvenile court did, I don't believe there was error. There was clearly an interest involved, which is the interest in placement as a relative, which was considered and rejected. And truthfully, the appellant's real concern here is the rejection of her as a placement, really not her intervention.
Isn't that circular though? Because the court says you have a potential interest in being a possible placement. Now I'm going to decide that I don't value that interest, or I'm not going to grant that interest. And then the court actually says in its ruling, basically, how does he say it? The court does not find maternal grandmother's rights would be compromised if she's not allowed to intervene. So the court's looking at that protection of rights in 24A2. And it says, well, since I'm not going to countenance your rights, they can't be compromised, right? I'm not going to place it with you, so your interest has no value. But that to me is getting the cart and the horse in the wrong order. Shouldn't they be granted a right to intervene, at least for the purpose of this, before we decide that they don't have an interest the court's going to value? Do you see what I'm saying? That the court's
Okay.
making kind of a merits decision in order to deny the motion to intervene.
Yeah, maybe there is a little bit, but functionally, the court, in fact, did, consider her interest, and really her arguments are really essentially she's equating a preference with an entitlement, and a preference is just a preference. It's,
Well, this sounds a lot like a harmless error argument, and
That's
this is
what-
why
yes.
why we asked appellant's counsel this question, like, how would it have been different if you'd been entitled, given the right to intervene? How would that hearing have looked different? How would you have been heard differently or whatever? And I think the answer to that question was, well, functionally at the hearing, not really, wouldn't have really been different, but it seems like there is one functional difference, and that is the right to appeal, right? If you're a limited purpose party for the purposes of making that request, and you don't like the merits ruling that's ultimately made about that request, then you have the right to come up here and appeal the court's decision with regard to that request. But if you're denied the right to intervene for any purposes at all, then you're a non-party, and non-parties can't appeal, right? So what's your response to that?
I'd say, first of all, obviously it's an interlocutory, so any right to appeal would be a permissive right to appeal, not an appeal as of right. Because this court's already ruled in HJ that the denial of an interim, placement is not a final appealable order.
Right.
I guess that, as a party though, they would have the right to at least ask for permissive interlocutory review.
Right, I think that's right. And what about at the end, right? What about, let's say that decision is, when it comes to the, we're past adjudication, we're into the sort of disposition, the permanency phase. Permanency phase is, hey, we're not going to try to reunify now. We're going to look for some other placement for these kids, whether it be adoption or something else. Does somebody who has a relative placement has the right to make a request under the shelter statute for a preferential treatment as a relative? Do you think they would have a right to come in at that phase and assert that same right, or is that right, in your view, only limited to the shelter phase?
I think it's a limited right to shelter. Hypothetical, let's say that the case went south and eventually the parents' parental rights were terminated and you're looking at an adoption by a foster placement or another different kinship placement. Say at that stage, would the grandmother have a right to appeal that decision and go back and say, you erred way back here by not placing the kids with me, and I really should have them? Is that essentially what you're saying? Is that she would lose? And I think that's not. I mean, I think she does have the limited right to appear at the shelter phase, dispositional phase, to say, here I am, I'm available, I'm a placement. But to the extent she hasn't made any additional filings, I think that her hearing on the merits of that issue is kind of her shot at bite at the apple. I mean, if she wants to file a petition for custody, she wants to file a petition for termination of parental rights, she wants to file her own petition, alleging abuse and neglect, she wants to even join in the state's petition alleging abuse and neglect. I think under Rule 24, that gives her, I think that's really should be the test for an interest in this, is actually, I have something filed that I want to have adjudicated by this court. Just like your analogy of a father who's seeking to adjudicate his paternity. I have an interest before this court, I have a filing. Not just the kind of inchoate interest that this court has established and that the shelter hearing establishes, that the right to be considered and to be preferentially considered. Is that helpful?
Thank you.
And so, I think it has been, I think people, I know there's several cases pending now where people are kind of struggling with this issue, are you a party, are you not a party? And I do think the notion of probably a limited intervention is the most useful. As Judge Luthi said, Section 301 seems to grant it, Section 18E seems to grant some degree, to the extent your interest is being considered, for those purposes, you are there in front of the court, but not for all intents and purposes and for all times to the end.
So just so I get your position on the record, since I was a little surprised from the Guardian's position, what's your position as you stand here today with regard to limited purpose intervention for the purposes of the disposition only?
I think that's a reasonable way to, it's not exactly how we briefed it, but I think that is a reasonable way to look at it and a way to describe what they are, you say, the statute gives them a right to appear, present information, to be considered. So to some purpose, they are a party. But are they a party to the state's petition? Are they a party to a subsequent termination petition? Probably no. But with respect to their interest, and their interest is what's given them by statute, which is the right to be considered. And I think for that purpose, yes, they are. And perhaps if the court determines that, then that probably would give them the right to at least request interlocutory review of the denial of that, which I think is also probably fair.
And in light of the fact that the briefs were really focused on Rule 24, all or nothing intervention, and not some sort of limited purpose dispositional intervention, do you think supplemental briefing is warranted?
I think it might be helpful. I think it's an area where there is some confusion, and I think, just judging from all the calls I've had in the last week about this, I think that people could use some instruction and some elucidation about who's a party, who's not a party, and stop fighting these battles. And you certainly don't want to hear from everybody who's attached to a motion to intervene to their appearance, direct appeal on that either. So, I think that probably would be warranted in this case, and just on the issue of more, I think, what would be the procedural mechanism to establish a limited intervention right, and whether it's statutory or rule or a combination of the two.
Right, that's exactly what you can tell we're struggling with that. Yeah, thank you.
And the only other thing where I just noticed is going to the merits, which I think are not really in front of this case, that Section 83-302-8A really suggests that the only person who even needs to be considered is a relative who is willing to facilitate the goal of reunification, which grandmother's not. in this case. So I was, at the start, from the outset, I don't know that she even really falls within the entitlement of a person who's entitled to be considered, given that she doesn't fall within the statute.
On that note, where does that become clear in the record or through the course of proceedings? Where would we point to in the record to say, here's the first time we know that the grandmother is not supportive of the reunification goal? Do you know?
Off the top of my head, I think it's in my brief, and I think it's in, I believe, I know it's in the juvenile court's ruling on the matter that found that she was not, and it might have been, it could have been, it likely was made in the argument, regarding her consideration as a placement, and I'm sorry, I could find it and add it, but off the top of my head, I don't remember where
Okay.
that.
Thank you.
And if there's no further questions, I'll submit it on that.
Thank you.
Thank you, Your Honor.
Mr. Bynes.
I think this court has the same questions that my client had, and the same questions that I have. And that is why does there appear to be some conflict between these various statutes? And I think that there is. And I think certainly there needs to be some clarification with regards to each of these.
And given the exchanges that we've had today and the idea of limited purpose intervention and the FL case that perhaps could have been briefed more fully and the Brown case that's related to it, what are your thoughts on some supplemental briefing?
We would certainly defer to the court. If the court was so inclined to request that, we would have no objection.
Would you want it?
I'm not sure that any attorney wants more.
That was maybe a dumb question in some respects.
Well, it's another,
But-
it's another opportunity to persuade. Do you want, do you want that?
And I think that it would be beneficial. So,
If the court went the route of some sort of limited purpose intervention to make sure that, that your client is a party to the decision on shelter placement and not considered something other than a party, but has a seat at the table for that decision. It seems like, as a practical matter, she had a seat at the table and that you were there, she was there. You were able to put on evidence as to why she ought to be the shelter placement, and the decision didn't go down the way that you all hoped. But practically speaking, what would she have gotten as a limited purpose party that she didn't get the way things actually went down?
well, she would have been able to actually put on evidence, and we could have brought in other persons, counselors, in support of that, and we were not afforded that opportunity.
You did
That's-
not get to put
No,
on
we did not
evidence.
get that opportunity. That's what we were prevented from doing. So,
And you think you would have gotten that as a party?
I believe so, yes.
And what would the difference have been there? Why would the judge have allowed that if you were a party, whereas it wasn't allowed?
Well, because if you're a party to the case, each party has the opportunity to present evidence in support of their position. And by not being a party, my client wasn't afforded that opportunity. If I might address one issue that come up by opposing counsel, and that was the opportunity to file other briefs. To my understanding, I don't know that there is any authority out there that would require a appellant in this situation to file anything other than what we already did. So I don't know that it would be a requirement that she would have to file something other than what we did file.
In fact, to me, it seems like perhaps merely filing a request to be the shelter placement would be all that you would need to file. Not even a motion to intervene, but under the statute, you're allowed to file that request, and only parties can file a request. So by making, you don't have to file a motion to be a party to file a complaint or to file an answer. The statute gives you the right to make that filing. As you make that filing, you become a party. It seems to me. Would you agree with that?
I'm not sure what else that she would file for a request in this situation. We did make a request, for her to actively participate and be a part of the case, and for placement. We were just denied that as not being a party to the case, so.
I think that's all we have.
Okay, thank you, Your Honor.
Thank you all. This is a difficult one, and we appreciate you all engaging with us here, and we'll continue to engage. And if we determine that supplemental briefing is necessary, we'll let you know of that as well. Thank you.